Do you know that the nullity of a marriage can affect all the parties to the said marriage contract? Do you know that when a marriage is null, all parties to the contractual agreement, in this case marriage, not just the husband and the wife, but both families that entered into the marriage contract are affected when there is nullity of marriage. And the effect, however, could be both positive and negative. Hello, my name is Ogochukwu Onoha, and I am the Human Rights Wizard, your usual anchor person on Human Rights Heralds, a half hour with the Human Rights Heralds. In our discussion today, we shall be trashing out the meaning of the word nullity as it applies to marriage. But if you are joining us for the first time, I'd like to let you know that for some time now, our searchlight has been focused on issues related to marriage. Human Rights Heralds is a channel dedicated to simplifying the law, to reducing the technicalities of the law to a level where lay people, ordinary people like you and I, can understand and have a better appreciation of the law. And in so doing, we get to know our rights better, we get to understand how to go about knowing our rights and protecting our rights and defending our rights, and how to respect the duties which the law has imposed on us in our relationship to other citizens or to other people around us in the society. In our immediate past videos, we talked about customary marriages and statutory marriages, that's marriages contracted under the customary laws and marriages contracted under the British-derived English laws, which we refer to as statutory marriages. Marriages contracted under the Marriage Act of 1914. In those videos, we discussed the meaning of a void marriage and a voidable marriage. We have also talked about divorce under customary marriage and the consequences or effects. Today, however, we are talking about nullity of a statutory marriage. A statutory marriage is the one that lay people commonly refer to as the white wedding. Before the white wedding holds, however, there is usually a registration of the intention of the couple to get married and live like man and wife in the local government registry, where there is an official called the local government marriage registrar who registers a couple's intention to be married. It is only such a registration which results in the couple being issued with a certified federal government owned or federal government issued marriage certificate. That is what makes the so-called white marriage valid. Nullity is an English word. It means non-existent. It means of no effect. It means ineffectual. So, a nulled marriage is a marriage that no longer exists, even if it existed prior to this. A void marriage is one that never existed in the first place, even if the couple is living together, even if the two parties involved have been living together. In law, it can best be said that such parties are cohabiting. They are not married. A voidable marriage is a marriage that has been legally contracted. A marriage that has met the requirements of the law and the parties are living together as man and wife. But there are elements in that marriage, conditions in that marriage, that could make a law court declare it void if any of the parties involved takes the matter up. All of these have been discussed on our previous videos. You would do well to watch those videos, as they would provide an important background for you to have a better appreciation of what we are discussing on this video. Let us give it a push. Nullity of a statutory marriage. A marriage remains valid until a law court nullifies it. Now, if a marriage is nullified, no one party to the marriage agreement has a claim to make, because there was no marriage in the first place. So any claim that existed prior to the union ceases to exist once the marriage becomes a nullity, or once it is nullified by a law court. On our previous videos, we identified five conditions that can render a marriage a nullity. These conditions make a marriage valid, but if any one of them does not exist, then the marriage is a nullity. A law court can declare the marriage a nullity. In certain circumstances, however, a marriage that is valid at its inception can become a nullity, can be voided, if one of the parties takes the matter up in a law court and is able to prove that there is a condition of that marriage that renders it voidable. Then a law court can void the marriage. But until the marriage is voided, all the rights, all the privileges available to the parties are intact. The parties continue to enjoy all the privileges and all the rights, all the perquisites conferred on them by virtue of their being married until the marriage is voided by a law court. Now let us talk about the five conditions that can render a marriage, or that can predispose a marriage to be nullified or to become a nullity. One is if one of the partners consistently refuses to consummate the marriage. I bet the word consummate is big to some of our listeners who are lay people. It is a language of the law. To consummate means to make the marriage real through sexual intercourse. A marriage is consummated after the first act of sex or sexual intercourse between the partners. Of course, it is possible, like is often the case in our modern society, that the parties already had a carnal knowledge of themselves. They had already had sex before their formal wedding. This doesn't count at all. We are talking about the period after the marriage had been formally established. There has to be a first act of sex. Then we say the marriage has been consummated. If one party, the woman for instance, consistently refuses to allow her husband have sex with her, even after that husband has repeatedly demanded the same sex, and the woman has persistently refused to allow him to have sex with her, that is enough ground for a law court to nullify the marriage or put an end to the marriage if the man applies to a law court. The same is obtainable if the man is the party who consistently refuses to have sex with his wife, even when the woman comes to him demanding the same. If the woman applies to a law court, the court can nullify the marriage. I know that a variety of questions arise in our minds now. One of such questions is, can a partner in a marriage situation lawfully deny the other partner sex? The answer is no. And the answer is also yes. So there is a middle course. In certain circumstances, a woman can deny her husband sex even when they are married. A man can deny his wife sex. What are those conditions? Now, if a woman is sick, is ill, and is visibly sick, and it is known by everyone that she is ill, she can deny her husband sex until she has fully recovered. But it becomes unlawful if the woman uses the pretext of illness to consistently deny her husband sex. If she does, the man can apply to a law court and get the marriage nullified. If the man is the one who uses illness as a pretext to deny his wife sex, the woman can apply to a law court and get the marriage nullified. The other issue here is, can a man obtain sex by force from his wife? Especially when the woman is denying him sex. No. If the man does that, it becomes rape. Can a partner lawfully, is it a provision of the law that a man can rape his wife or a woman can rape her husband? Yes, there is a provision of the law against that. Even in marriage, sex can only be obtained by consent. The woman must give the consent before her husband can have sex with her. The man must give the consent before his wife can have sex with him. So, if the man forces his wife, or if the woman forces her husband, it becomes rape. And the party who is the victim can apply to a law court. And the law will take its course. And the punishment provided for rape in the law will apply to the party who committed the offense. So we go back to our question. Can a partner lawfully deny his spouse sex in marriage? No. No. Even though a partner is not permitted to do this lawfully, it is still a crime if the other partner tries to force him or her. But repeated denial can result in a marriage being nullified in a law court if the victim applies to the court asking for such a nullity. We have talked about the first factor that predisposes a marriage to nullity. We now talk about the second factor. The second factor is impotence. If a partner discovers that his spouse or her spouse cannot possibly make her bring a fulfillment of her marriage through sex. Fulfillment here means pregnancy. If a man is discovered to be impotent in his marriage, he does not produce sufficient sperm to make his wife pregnant, or to fertilize his wife, or he suffers from a permanent erectile dysfunction. The man does not get an erection, or he has a genital, a penis, too tiny to be able to perform the function in such a way as to get his wife pregnant. That is enough ground for a nullity of that marriage if the woman applies to a law court. What if the man is not the problem? There is a healthy sexual relationship between the man and his wife, but the woman is not able to conceive after several attempts. They've been to hospitals and the man is certified healthy, and the woman is certified unhealthy. There is something wrong with the woman's reproductive system, so she is not able to get pregnant. The man can apply and get a court nullify the marriage. But either of these is possible only if the partner who is the victim did not have a prior knowledge of the situation. If the partner didn't know that this is the case before they got married. In other words, the partner who is important kept the knowledge from the other partner until after the marriage. It is enough ground for the partner who is the victim, the partner who has suffered the injury, to apply to a law court and get the marriage nullified. However, if the impotence is one that can be treated and the partner involved is willing to receive medical treatment, then the other partner must have patience until the impotent partner has his potency or her potency restored. But the court will nullify the marriage if the impotent partner consistently refuses to receive medical attention. Then the court will nullify the marriage. I guess that point is clear. Impotence. Now, the third conditional factor is mental impairment. Mental impairment, insanity, or epilepsy. That is, a partner is mentally deranged, is unsound upstairs, like we put it colloquially sometimes. The partner is suffering from insanity, has an unsound mind, or is suffering from a disease called epilepsy. It is enough ground for the partner, the other one who has suffered the injury, to apply and get a court nullify the marriage. However, if that partner had the knowledge that this is the situation before getting the marriage, before going into the marriage, the court will not nullify the marriage. And if the insanity, the mental derangement or impairment, or the epilepsy is curable, and the partner who is the victim, the partner who has the disease, is willing to take medical treatment, then the court will not nullify the marriage. The other partner must wait patiently until her partner or his partner is returned to a sound mental state. Now, in both cases, number 2, that is impotence, and the third one we are talking about, mental derangement, epilepsy, or insanity. In both cases, the court may refuse to grant the request of the partner who wants the marriage nullified. If nullifying the marriage will result in greater hardship, will bring hardship that will be greater than the one the partners have while staying in the marriage. I guess we understand the point. There is almost no possible detailed definition of what we mean by greater hazard, greater hardship. But if the situation the partners will find themselves, if the marriage is nullified, is worse than what they see staying in the marriage, then the court will not nullify the marriage. Now, we talk about our fourth factor or point. The presence of a venereal disease, of a contagious or communicable nature. What are venereal diseases? AIDS is venereal, a disease that can be passed across to another person by touch, through contact, or through the air, or by some other means, is contagious, is communicable. AIDS is an example. Another is syphilis. Another is tuberculosis. There may be many other such diseases. It is not my intention to name all of them. I am not so, it's a medical field where I do not have all the facts. But the existence of any such disease in a partner is enough ground for the other partner to apply to a court and request that the marriage be nullified. But this is possible again if the partner applying for the nullity of the marriage had no prior knowledge of the condition, had no prior knowledge before he got married. That partner didn't know that this is the situation. In other words, the other partner hid or concealed or refused to reveal the fact that he or she has this medical condition. But if the condition is curable, syphilis is curable with the right medical attention. Tuberculosis is curable. If the disease can be cured, then the other partner must have patience, especially if the partner who has the condition is willing to take medical care, to receive medical attention. Then the partner must have patience until the sick partner is restored to wholesome health. But if the condition, like HIV/AIDS, is one that is incurable, then it becomes an entirely different ballgame. What will happen? The court will dissolve the marriage, at least to save the other partner from the hazard of staying close to such a person. That is what will happen. So when I talk about the fifth and final factor, pregnancy. If the woman is discovered after the marriage to be pregnant for another man, automatically her husband will apply to have the marriage nullified, because he cannot marry a woman and welcome a strange child into his family. It had been stated in one of our previous videos that a man cannot marry a woman along with a child that the woman had for another man. The father of a child is his biological father. The man who is responsible for a woman's pregnancy is the father of that child and can claim his child anytime. Even if he never married the woman, he never paid any bride price, he never contributed anything to the raising of the child, he denied being responsible for the pregnancy, disowned the child and his mother. But sometime along the line, he came back to his senses and decided that he had to claim his child. If he goes to a law court, the court will award custody of that child to the man and not to his mother. That is the law. So, the discovery that a woman is pregnant for another man after her marriage is a condition that can lead to the nullity of that marriage. If you have enjoyed our video today, if you have enjoyed our session, you can show this. You can envis this by sharing this video, by liking and sharing this video. You can also subscribe to our channel so that we can give you more videos of this nature, and you can always receive our videos direct into your inbox. My name is Ogochukwu Onoha. I am the Human Rights Wizard, and the session is half an hour with the Human Rights Wizard. The channel is Human Rights Heroes. I invite you to join me on our next video, where we'll continue to analyze issues that affect marriages. The family is an important agent of socialization, an important unit of society. Therefore, whatever happens to the human family affects the entire society, which is why it is paramount that we understand the do's and don'ts in a marriage situation, our rights as spouses in marriage, our duties as spouses in marriage, so that we will be able to produce families that will involve an enduring legacy of stability, of resilience that we can hand over to the succeeding generation. As I wait to see you or be with you in our next video, I remind you again that our slogan here is know your rights, protect your rights, and defend your rights. Stay away from trouble until we see you again. Bye-bye.